Hello, and welcome to our training on the role of public guardians and conservators in petitioning. Today, we have two major sections of a conversation. First is we will have some folks from our training and technical assistance team provide an overview of care, so describe the purpose of care, touch high level on eligibility, and list potential roles of public guardians and conservators. We will be including links to trainings for you to consult along with resources that will give you more in-depth information if you're wanting to know more about eligibility, the care process, or what's involved in a care plan or care agreement. The second half of the conversation will be public guardians and conservators on the ground, where we will hear from folks who have been in both roles, both in the public guardian office and working with care teams, and hearing how they are integrating these two programs and working with individuals who are going between them on the ground in counties who have already implemented care. Our objectives for today is that by the end of the session, you will have an increased ability to identify those unique aspects of care, including different paths through care and the range of services included, and understand how care can be a less restrictive alternative to conservatorship, and then describe the role of the public guardian or conservator in the care process, mainly as a petitioner or someone who can refer to care. So today we'll be sharing a live recording that we had, and you will hear from a few individuals. So from the Care Training and Technical Assistance Implementation Team, you'll have Dr. Deborah Rose and Dari Pogash from Health Management Associates talking about care and how public guardians and conservators can be integrated into that process. And then we're really pleased to hear from Dr. Brock Colby from Tuolumne County Behavioral Health, and then Melody Colhane, who is with San Diego Behavioral Health Services, again to speak to their experience and how that is working on the ground. So with that, I'll turn the time over to that live discussion.
Hi there. We have an important update regarding the CARE Act beginning January 1st, 2026. Changes made by Senate Bill 27 will go into effect. These changes include bipolar 1 disorder with psychotic features will now be included as an eligible diagnosis under the CARE Act, except psychosis related solely to intoxication. This law now defines what it means to be clinically stabilized and ongoing voluntary treatment. Certain court referrals can now serve as a care petition. Criminal courts may consider care referrals earlier for individuals found incompetent to stand trial in misdemeanor cases. Nurse practitioners and physician's assistants are now authorized to complete affidavits in support of care petitions, and there are also some technical amendments to streamline the care process. Our training PDFs, including the notes, have been updated to reflect these changes, including the addition of bipolar 1 disorder with psychotic features, and they are available on the CARE Act Resource Center. But during this training video, you may hear older references to schizophrenia and other psychotic disorders, so keep this update in mind that it will now include bipolar 1 disorder with psychotic features starting January 1st, 2026, and other updates made by Senate Bill 27. Thank you for staying informed, and please review the updated resources linked in your training materials. You can find more information about these changes in our SB 27 brief on the CARE Act Resource Center, or email us at info@careact.org.
Thank you, Patricia, and I want to thank others for joining us today. We appreciate you choosing to spend time with us. Really excited to present with Dari, Brock, and Melody, and so I think we should just dive in. Today, we're going to give you a high-level overview, as you can see from this slide. CARE is a new civil court process, and like conservatorship, works with many folks who are living with serious mental illness, specifically people with schizophrenia and other psychotic disorders. Unlike conservatorship, perhaps, CARE is less restrictive, and it's an early intervention option. It's really designed to focus on autonomy and recovery to enhance a person's ability to live independently in the community. The CARE Act has created a new roadmap. It delivers behavioral health and substance use disorder services to some people who are living with really complex behavioral health conditions. And as a result of their conditions, often these people end up homeless or housing vulnerable, often have involvement with the justice system. And so again, care is designed to be upstream to those kinds of outcomes, connecting people to comprehensive services. There's a lot of paths into care. Each of them begins when somebody files a petition. Generally, that means that the petitioner believes that the individual may be eligible for care or is eligible for care, and that they think the person would benefit from additional support. There's also a number of paths out. I think what's really important to recognize here is that services and supports doesn't end when the care process is over. This is really designed to keep people engaged in the community, to keep continuity of care of services so that people can continue to receive care with a small c. We say that sometimes. And so really the goal of this is to provide person-centered upstream services and supports for people who otherwise may be at risk for more restrictive interventions. You'll see, and I'll say it a couple of times, that there are a number of links at the bottom of your screen, and you can find more information about the care process workflow and other information. Let's go to the next slide. Thank you. So what I really like to do is start by why care? What can it do? What are we trying to achieve in this process? Really, the idea is to create a package of person-centered services that support somebody's autonomy and recovery. And it could look different. It should look different for every person, but it can involve a lot of different features. And there are a number of boxes on your screen that talk about them. I'm not going to read them all, but I'll highlight that this is really about beginning with trauma-informed outreach and engagement. Thinking about where people are, how to connect with them, how to provide maybe concrete services, socks, food, transportation assistance that help engage people in care. It's also about creating a plan that provides comprehensive wraparound support services. And that includes care coordination, which means who's the conductor of this orchestra, right? There are lots of first chairs. Who's pulling it all together to ensure that all of the service providers are talking to each other to ensure that there is this comprehensive and integrated system of services? That system is generally multidisciplinary, so it means that people from different professions and backgrounds are coming together. In your community, it could be an assertive community treatment team or an ACT, which is like a clinic on wheels, a full service partnership or an FSP, or it can be care management services through CalAIM. Like I said, comes in different forms, but the idea is to have somebody pull together services to support the care plan or the care agreement. It could include supported housing or other types of housing, medications that an individual would benefit from. Really important, peer recovery supports, people who have lived experience of recovery, who can connect to individuals. And then two other things that I'm going to mention are psychiatric advance directives, which means that an individual's wishes, preferences, and needs are documented in a way that others can understand them. That can be used both through the care plan and used after, so that we know what's important to an individual. And also, I volunteer supporter, and this is a person who is chosen by the respondent to be part of the care process to ensure that that individual's choice and voice is heard. Most important, and especially on this call, given the audience, is that care is really designed to be a less restrictive option to conservatorship. And so keep that in mind as we go through the remainder of this presentation, that we're looking at this package to help uplift people and to help them regain or maintain autonomy and recovery in the community. So let's go to the next slide, please, and consider eligibility. Who is care for? These are adults, 18 and older, people who are living with a serious mental illness, most notably schizophrenia or other psychotic spectrum disorders. Care is designed for people who are not clinically stabilized in outpatient recovery or treatment services. So perhaps somebody is involved with a treatment provider, but not regularly, or isn't doing well. That person may qualify for care. Importantly, is that care is a least restrictive option, and it's really necessary to support a person's recovery and autonomy. And then Likely that the person will benefit from care, and that's a big one. Will somebody be assisted and supported by the services? In addition, one of two things need to be true. Either the person is unlikely to survive safely in the community without supervision, and the person's likely to deteriorate, or the person is in need of services and supports to prevent relapse or deterioration. And likely that would end up resulting in a grave disability. So again, all of the following, and then at least one of the following from the bottom of your screen. Who can petition the court? There are a number of eligible petitioners, a wide range of people can do it, and there's a broad list that you're seeing on your screen. Important to note that more than one person can be eligible to participate as a petitioner. And so ideally people collaborate, different people who are connected to the individual, who have different pieces of information and who are all invested in that person's recovery and treatment can come together for a care petitioner. For a care petition. This can include lay people like a family member or a roommate, a housemate, or the client themselves. We are hearing that some folks who are in carceral settings with the support of an attorney have been petitioning on their own behalf. Other petitioners include system partners, notably here, a public guardian or a public conservator, licensed behavioral health providers, first responders, including homeless outreach workers, and then various professionals, including a director of a hospital or a charitable organization, and importantly, the county behavioral health agency. A number of these eligible petitioners also can appoint a designee to act as a petitioner on their behalf. Again, for more information, there's a number of links at the bottom of your screen.
Since this training was originally recorded, the petition forms produced by the Judicial Council of California have been updated as of July 1st, 2025. So we wanted to just go over some of those changes and provide some general guidance about completing the petition. So the purpose of the petition, remember, is not to prove everything up front, but to give the judge enough information to decide whether the case should move forward. Based on what's submitted, the judge may either dismiss the petition or ask the county behavioral health agency to investigate further. The petition doesn't need to be exhaustive. It should include what you know and have observed and enough to reasonably believe the person may meet the care criteria. So there are two different ways to file a petition depending on who you are and what information you have. Regardless of which option makes sense for you, the petition will ask for information about the petitioner, information about the respondent, such as how to contact them and any language or accessibility accommodation that may be useful, and information about a court referral, if applicable. The bulk of these forms will focus on capturing information related to an individual's potential eligibility. So let's talk about these two options. So the first option that you see on the top is a general petition process that would make sense for most petitioners. You would use this path if you're not a licensed behavioral health professional, for example, family members or first responders. Step one would be to fill out the Care 100 form, which lets you explain your observations in your own words. And step two would be including one of the following to support that petition. So the Care 101 form. So this would be a declaration from a licensed behavioral health professional who's either examined the individual in the last 60 days or has tried multiple times. And they must believe the person may meet the care eligibility criteria. So the other option to accompany the Care 100 form is documentation. So this would be evidence that the person has had at least 2 intensive treatment, one within the last 60 days. So this could include hospital discharge papers or a signed declaration for someone with direct knowledge of those hospitalizations. So if the person completing the petition, the Care 100 form, has direct knowledge, the declaration of the 250/250s can be included directly on the Care 100 form. Otherwise, that information can be attached to the petition, like I mentioned, a hospital discharge paperwork, a declaration from a witness, or other evidence of those 250/250s. So that's option one. Option two is a streamlined process for licensed behavioral health professionals. So you would use this path if you are a licensed behavioral health professional, which could include members from county behavioral health agency. So for this option, you would only fill out the Care 102 form. This combines both the petition and the declaration from the licensed behavioral health professional into one document. Like the Care 100 and the Care 101, this Care 102 form allows you to describe what you've observed and why you believe the person may be eligible for care. Regardless of which option you use, the key is to provide enough detail for the judge to decide whether the case should proceed, not to prove everything. If the judge believes there's a reasonable basis, they may request more information or begin the formal care process. Just document what you know and keep the focus on what you've personally seen or learned. For more information about the mandatory forms, you can see the forms on the Judicial Council website, and there's many resources on the CARE Act resources for petitioners page, including additional tutorials and information for different petitioning groups.
Thanks, Deborah. That was a really great foundation, laying the groundwork for the care process. And so I'm going to go back through some of the points Deborah made, but look specifically at how they apply to public guardians and public conservators, and then speak to some other types of referrals as well. So what is the role of a public guardian and public conservator in the CARE Act process? So there's two general roles. First, as a petitioner, the public guardian or conservator can petition for care. And they would file a petition like any other petitioner with the understanding and the belief that that individual may be eligible for care. But there's another way that a conservator may find themselves petitioning. If a conservatorship court refers an individual to care under the care statute, once the referral is made, the conservator or proposed conservator who's involved in that conservatorship judicial process will become what's called the original petitioner or the petitioner for care. But then, of course, there's that collaboration that Deborah mentioned a few minutes ago. And we'll talk more about this in detail in a moment, but truly the guardian or conservator could consider collaborating with other eligible petitioners to complete a petition. We can move to the next slide. Thank you. Okay, so let's talk some more about public guardians and conservators specifically as a petitioner. The petition may be filed by the public guardian or the conservator of the county in which the respondent resides or is found. And this includes the guardian or conservator can have a designee as well to file that petition. Care fits into conservatorship. It's a less restrictive alternative to an LPS conservatorship. So if the conservatorship court refers someone to care, like I mentioned in the previous slide, the conservator or the proposed conservator will act as the petitioner. And then this is like any other original petitioner who's not the county behavioral health agency. If the court determines that the petition indicates eligibility, that the court makes a prima facie finding of eligibility for the individual, then the county BH will replace the conservator or the guardian as the petitioner. But the conservator will remain involved within the limits of their court-appointed authority. So that's the authority, of course, that's appointed through the conservatorship process until the conservatorship is actually terminated. So let me just say that one more time because there's a lot of moving parts here. So once the judge in the care court makes a prima facie finding of eligibility, the court will then appoint county BH to replace the conservator as the petitioner, but the conservator still remains involved with the individual within the scope of their court-appointed authority as conservator. Next slide, please. So we talked about guardians and conservators as petitioners. Let's talk about them now as partners. So I know everyone on this call understands that someone who may be who's been found eligible for quick care or may be eligible for the care court process may be involved in several different service systems within the county. And so the guardian and conservator can communicate with other eligible petitioners to understand the individual's mental health history and needs, and then determine who is in the best position to file a petition. And these collaborations may look different in different counties depending on how your services are set up in your specific county. Collaborations could occur with the county BH agency, other behavioral health professionals or facilities who are involved in the individual's care, adult protective services, and mental health courts. And when these collaborations occur, if possible, consider communicating not just about the person's needs, but also, again, like I mentioned, really who knows the person best, who has the most resources, which agency or system has the best resources and is in the best position to be the original petitioner in the care court process. And we can move to the next slide, please. So there are a few ways that a person can be referred from court to the care process. There's the LPS conservatorship process. And like I mentioned previously, in that case, when the conservatorship court is referring the person to care, then the conservator or proposed conservator will become petitioner. A misdemeanor incompetent to stand trial or missed court can also refer an individual. When this happens, county BH is the petitioner. And according to the statute, the charges are dismissed 6 months after the referral to care, unless the case is referred back to the criminal court before that time.
Me or you?
And similarly with assistant outpatient treatment, AOT, the court can make a referral, and then once again, county BH is the petitioner. But just speaking, in light of, we're talking about collaborations between conservators and guardians and other systems, so it's important to understand where these referrals can come from when talking about, because they may come up for you or for the conservator or petitioner, even if the referral doesn't come from LPS court. Okay, on the next slide, we're going to talk about another source of referrals for the CARE Act and how they may impact the work of public guardians and conservators. Hospital referrals. So designated facilities treating an individual under an involuntary hold may make a referral to the county behavioral health agency to consider a person petitioning for the individual for CARE Act for the care court process. And that referral can be made as soon as clinically indicated, but within 14 days of referral, the county BH has to assess the person and file the petition. And a facility cannot continue an involuntary hold just for the purpose of allowing county BH to complete the assessment. I do want to also just mention that under the statute, a designated facility is defined as a facility that provides assessment, evaluation, and crisis intervention, or is designated under the statute. And with that, I'd like to pass it back to Deborah. Thank you.
So let me just quickly talk about what happens after a petition is filed. And Dari has gone through this. I'm going to mention it again. So first is that the PCPG will be replaced at the initial appearance by the county behavioral health agency. But it's important that at that first hearing that the original petitioner appear. The hearing, and I'm sorry, I have some background noise going on, but the initial appearance is generally short. We're hearing that many of the courts are allowing remote appearances, but without the initial petitioner, it's possible that a case could be dismissed. So again, at the hearing, the initial petitioner is replaced by county BH, and then a conservator or guardian can remain involved, appropriate to their position and to their role. And ultimately, the conservator team will determine and decide when to schedule a hearing to either reappoint or to terminate conservatorship. So that would work in collaboration. I'm going to quickly mention, if we fast forward about a year, in July of next year, the court will also be informing family members or a roommate who's petitioned the court about participating in care proceedings. For now, it does remain that it's people of the individual's choice or conservator guardians. So I think we can move to the next slide. And this is a big one. We get this question a lot. What happens if somebody chooses not to participate? Again, care is not a criminal process. It's a civil court order, so there are no criminal consequences for a lack of participation. If the person decides or chooses not to comply with a care agreement or a care plan, with the exception of medication, the court could determine if participation should be considered in LPS proceedings if it occurs within the following 6 months. So let me say that again. I'm going to read this so that I'm getting it straight. And if I'm not, I know that Daria is going to pop in here and is going to help me out. So if a person chooses not to comply with the care agreement or plan, the court can terminate the participation in care, but they can't consider the medication part of it. Those are considered separately. If LPS proceedings happen within 6 months of the termination, the non-participation may be considered by the court. Important to note, though, that non-adherence or non-participation with care doesn't automatically lead to an LPS proceedings. And again, while the non-participation could be considered, non-adherence to medication cannot be included in those considerations. Okay. I think we've said this a number of times that the court can use its authority to refer or for consideration of conservatorship if they believe that the person is a safety risk and that that authority is pre-existing. It doesn't relate solely to non-compliance. That's a standalone, and that all of the due process for a care petition remain the same. So all individuals are entitled to the same process for the referral and for the processing of a care petition. I think that we can continue to one more slide. And Daria, I'm going to ask if you can come back and join me for this one. Maybe we can both be on screen. We like to put out a ideas in action, which gives us an opportunity to think about how we can take what we've learned today and what we've discussed and maybe apply it. And so we have here, consider the potential reasons for public guardians and public conservators to file a care petition. So maybe you can talk about what are some of the reasons and some of the thinking behind why a conservator or guardian might choose to go with a care route.
Sure, thanks, Deborah. I like to think about a care petition or considering a care petition as a tool in the guardian or conservator's toolbox. And it's a tool that can possibly serve as a less restrictive alternative to conservatorship. So one way, I think one reason is pre-appointment of a conservator. That conservators may want to consider petitioning because participating in care process is, of course, a less restrictive process than a conservatorship. It's a step towards the individual supporting their rights, supporting the individual's rights to make their own decisions about their mental health treatment because they can. It's a voluntary. They can participate in the process. So that's one way. I think it's also a tool to engage individuals with behavioral health services, even if a conservator has been appointed. And it's also a way to consider a step down from conservatorship. So perhaps the conservatorship is existing, but the individual may be ready for something less restrictive like the care court, and the care court process is that tool to try out. So those are some reasons. I'm sure that there will be more as more petitions are filed and we learn from more on the ground experience. But those are some of the ways that I would anticipate that public guardians and conservators may want to file for or consider filing for a care petition.
That's great. Thank you so much. And I like the idea, and I know we're going to hear from our colleagues the idea of maybe using care as a step down. So sneak preview, spoiler alert of what's to come. Well, I think we can move it forward. And I'm really pleased to introduce the next two the guest professionals who Patricia talked about earlier. These are people who both have care experience and they also have LPS experience. So we're getting the best of all worlds. And I'm going to pass it over to our first guest, Melody, who's going to talk about her experience of what it means to be working with care on the ground.
Thank you so much, Deborah. I appreciate it. My name is Melody Colhane. I currently work at the care office through behavioral health services. I was previously working at the public conservator's office, so I'm pretty knowledgeable about both programs right now. I've also worked in an ACT program and at strength-based case management and in the hospital setting. Regarding the transition from somebody moving down from a conservatorship to care, there are some steps that we take. Most importantly, I would say first, identifying the appropriate opportunities for petitioning to care. In San Diego specifically, we're designed for primarily two types of step downs. One, transitioning individuals from an institution like an IMD or a closed lock facility to the community living like a boarding care or independent living. And then we also work with individuals who are already in a community placement like a boarding care or an independent living, but they're looking to terminate conservatorship and take further steps in their recovery. The care team is looking at any reestablishments as well as ensuring clinicians evaluate conservatees for care eligibility. We have regular meetings with the public conservator's office and assigned case management program working with the conservatee. We also cross-trained several team members within our program to work in both care and the public conservator's office. Our court system, including our public defender and our judges, we all collaborate and have the same goal, which is to promote each person's recovery. Going from a conservatorship, residing in a very structured setting, and being forced to take medications for an extended period of time can have a positive effect if they're the most stable. So we review the whole picture and we ask them, are you willing to participate? What are your goals? Any barriers that may impede your recovery, like cyclical medication non-adherence when you're off a conservatorship? We also have regular meetings with the public defenders at least twice a week, and we regularly communicate with the public defender and the courts to review all participants. And we have multiple tracking systems with care providers to ensure that all the respondents and participants are getting their needs met. Secondly, it's really important to acknowledge that this is a collaborative process between both the public conservator's office and care to identify individuals, especially in the step down phase from an institutional care or individuals who are stable but may need additional assistance and support as they transition off a conservatorship. This can happen during a reestablishment for conservatorship, or just a routine look at any of the individuals who may need a lower level of care or have an eligible diagnostic criteria. We discuss how our care team is held to the highest standard because of the court oversight. The court aspect is less about the participant, and it's more about the accountability for the program providing the services, including housing and mental health treatment, as well as any of their recovery goals, whether that be reunification with their families, employment, increased socialization, whatever that recovery looks like for that individual. Thirdly, we understand the benefits of care and the accountability it provides for the services, which I just kind of touched on. Like I said, it's an intensive wraparound support system, meeting the individual's needs, particularly medication adherence. A large majority of our care participants are on long-acting injectables, and a large part is due to the case management program that we work with and their promotion of medication. It's also a great option for individuals who don't need the required structure of a conservatorship, but still need support. We work with the county behavioral health teams to ensure that they are accountable to provide the services. We don't want somebody to go back on a conservatorship. We want to encourage them to participate in the care program regularly. And we also, like I said before, we work collaboratively a lot with the public conservator's office and the public defender and the public guardian. With San Diego, the public guardian and the public conservatorship office is somewhat separate. The Public Guardian's Office serves more of the individuals who have dementia and less of the individuals that have severe and chronic mental illness. Not to say that they don't, but it's just less common in our county. But the Public Conservator's Office serves primarily most of those individuals. We also work to strengthen rapport and understanding among our providers. We understand there's a need for a greater awareness among our clinicians about the CARE program and the eligibility criteria. We foster a collaborative environment where providers can comfortably discuss when care may be appropriate. We regularly meet with the Public Conservator's Office to identify potential care respondents or participants. We also reach out directly to the CARE team to refer them. We also work with institutional case management to identify any potential step-down conservatees. So we also have regular meetings with them as well. And in order to simplify the process, we are all housed under behavioral health services, which means that petitions filed by a conservator are considered internal and do not require a separate investigation by county behavioral health. It makes it easier to move quickly for eligibility and then begin collaborating, which is why it's really important that we have these meetings regularly to ensure that we're screening people appropriately. It's clear that once a respondent will move forward with a care agreement, then the conservatorship team will consider scheduling a termination hearing. We talk directly with the person who is working on the termination investigation or a reestablishment to ensure that it happens the same day a care agreement is approved. We don't want any lapse, or we don't want the person to remain on a conservatorship longer than they need to, especially if they're participating in their care agreement. We want this to be very clear to that person. We also work with the current case management team that they're on. We communicate with them in advance prior to any sort of termination or care agreement hearing to ensure that they continue to receive housing and follow-up mental health treatment. For example, if somebody were to transition out of an IMD, we don't want them just to be taken off a conservatorship and then released and not have a place to go. So we work collaboratively with the case management program to ensure that those needs are met. So that's just a little bit of what we do. I can pass it back over to you, Deborah. Thank you so much.
Thank you so much, Melody. I love hearing you're using words like coordination and collaboration a lot. And both from an administrative perspective, what your teams are doing with each other to ensure continuity, but also what's happening with folks who are receiving care. And I so very much appreciate hearing how much you are working to provide services for people.
Thank you.
Thank you so much. So stick around because we are not done. I am going to pass this now off to our next guest and colleague, Dr. Brooke Colby.
Thank you, Deborah. Oops. Okay, thanks. So opportunities that we found with Care Court in Tuolumne County is it can serve as both a preventative alternative to LPS and as we heard in San Diego, a step down from conservatorship. So as a conservator, you don't have to be an expert in all the nuances of Care Court, but having this familiarity, as we've discussed today, and accessing the resources like from the CARE Act Resource Center, you can then decide when you're going to utilize this program as an option. And so oftentimes, as we're trying to create pathways that will prevent LPS conservatorship. And so, for example, we've often seen someone is put on LPS conservatorship, they go into placement for a year or two, and then they do fairly well and they're stabilized, and now they're ready to come back out in the community, and they get off conservatorship, and within a short time, they're decompensating, and it takes maybe a year to get them back on conservatorship and restabilize them. And so you sometimes, with some of these clients, you see a cycle of repetition. And so I think Care Court is a wonderful alternative to still provide some oversight to these clients when they're off conservatorship or as a step down so that they can still have both court oversight on how they're doing in treatment and, as Melody said, having a ACT team through behavioral health provide the intensive services to keep them in housing and keep them stable. So for Tuolumne County, for example, we enroll all of our care court in FSP, which uses an ACT model, assertive community treatment. And thus they are able to still benefit from intensive case management and rehab services to help address their symptoms and behaviors and help them stay in housing. Some of the things that we have when we're trying to create these pathways is we really, just like Melody says, we meet regularly with the LPS, with Public Guardian. We're still building our program. San Diego's way ahead of us in some ways to work on the step-down process. But we have an assigned liaison with our county that works with the Public Guardian and meets with them. We're establishing protocols for coordination between care and Public Guardian. And we've really focused recently on creating supportive housing opportunities for these individuals so that they'll have an alternative for some kind of supportive housing with services on site so that they'll succeed. One thing about, someone had a question about confidentiality. So when care court is initially, when behavioral health is initially assigned to be the petitioner, so someone petitions to care court and then they're assigned, behavioral health takes over the case and we are assigned to be the petitioner, then in the court order from the judge, he gives us permission legally to contact different medical providers in order to obtain records to both gather information to see if they qualify for care court and then present that in court. Now, what happens, let's say when a family member petitions, they petition, we're assigned, and now we have permission, but we no longer can talk to that family member without some kind of written authorization. So there is some limitations. And so what we do as a practice is obviously we ask all people referred to care court to sign releases of information to any entity, whether it's Public Guardian, a family member, et cetera, that we're dealing with. But the judge gives us permission in the care court orders as we're investigating the case to see if they qualify to contact different treatment providers and medical providers. In Tuolumne County, most of our referrals have been through family members mostly. And so back understanding those legal processes, who qualifies. And so as you become familiar with this, one of the primary requirements is you have to have schizophrenia, schizophrenia or a schizophrenia spectrum disorder or another psychotic disorder. And so that's, it serves a lot of the clients that we see in Public Guardian with LPS conservatorship, people with schizophrenia, schizoaffective disorder, et cetera. And so as we're looking at how to transition care in these programs, we really have to look at what are the responsibilities of the Public Guardian and what are the responsibilities of the behavioral health case management team. And so just having that communication has been helpful of who's doing what. But basically, the model we were using is the same, is how can we work with Public Guardian to address the problem behaviors and maintain the placement so that they succeed. And the same thing would happen with a care court respondent is, okay, we identified placement, and how can we make it succeed? And so it takes a lot of interagency coordination, because we have one umbrella organization, Health and Human Services, but we're different offices, so we're not quite as combined as San Diego is. And so we still have that siloing effect. And so we really have to make an effort to communicate. And then the fourth bullet on this slide, consider care as an alternative and less restrictive way to ensure people are connected to the right services. So oftentimes people may be referred to Public Guardian and may not meet the criteria for LPS conservatorship. Or they may be pursuing it and a doctor says, no, I won't do the physician declarations, or they don't meet criteria for behavioral health, but there's still a problem person out there. They're still struggling in the community, even if they don't meet the strict standard of grave disability to meet LPS conservatorship. But this could be a less restrictive way of a referral process. Okay, we have this problem person who's struggling, homeless in the community or about to become homeless. They possibly may meet the diagnostic criteria of schizophrenia. We're not sure. We can refer them to care court. And then that way, a determination can be made if they meet the criteria, and then they can get the intensive services. And then one last point is I saw someone asking about, I think, telehealth, and Tuolumne has successfully used telehealth with some of our homeless clients who would not come to court. And so that worked very well. Our judge was very open to working with us to try to find a neutral location with a homeless person who's paranoid, doesn't want to come to court, because most clients are afraid to come to court. They don't want to come. And so telehealth was an option that our behavioral health case managers were able to use. So that's all I got.
It's a lot. I thank you so much for joining us. Every time you are with us for one of the presentations, we learn so much. I appreciate hearing about the telehealth option. What a great way to really be person-centered and thinking about meeting somebody where they are. Court can be a scary place, and the opportunity to do it by iPad or remotely is a wonderful way to engage somebody. So thank you for that. I'm going to ask Brock if you can stay on, and Melody, maybe we can bring you back. And let's do a quick ideas in action, because I would love to know your thinking. And then I'm going to turn it back to Patricia after that. Let's go to the next slide. And I invite others who are at home or in their office looking at this to think about this, maybe jot down some ideas. So I'll ask you, if you're encountering somebody that might benefit from care, what approach would you take? So where would you start? Or certainly from the position of a conservator, you're coming from the care team now. So what approach would you begin or would you engage to begin that road? So with that, and with some background noise, I think that I'm going to pass it to Patricia, and hopefully we will have a chance to answer some of the many questions that have been coming in today. And again, I want to thank you, Brock and Melody and Dari, for joining me. Patricia?
Thank you, and thanks, Melody and Brock. And Brock, if you could follow up on one question we got in the Q&A. And again, for people, thank you for submitting your questions. We're responding to some as we can, and we'll likely circle back on some of these questions in tomorrow's open forum. So please join us for that. So Brock, with the question about Jennifer's question in the Q&A, since conservatives have stable housing on conservatorship, can we make a case to move them from conservatorship to care? How is that working in Tuolumne?
Well, I think I would argue that you're looking at, I want to step you down from a more restrictive legal status of conservatorship and allow you, the client, to not have that. Would you be willing to take advantage of this voluntary care court program and get off conservatorship? So you have a carrot. And how do you argue about the stable housing? I think it's back to my example of someone who repeatedly fails once they're off the more restrictive legal status of conservatorship. They don't have the oversight anymore. So it is voluntary, though. So the client can say, I don't want care court. But I think that if the client's given a choice, okay, I can get off conservatorship and I'm in housing and I can do this care court instead. How do you address it with behavioral health? I would argue that based on the history, repeated failures or failure in the past, we want to remove them down out of this restrictive standard to a less restrictive. Now, some clients won't qualify. If you're very stable in your board and care and you've demonstrated that for 9 months, why would you need to go to care court? But it's designed for the person who is really still struggling with stability. You don't have to be homeless. It doesn't say anything much in the act, I think, about homelessness at all, even though it's designed for homeless persons. It really is. There's a section that says if you're at risk of failure or if you're struggling. So we have family members, they're living with mom and they are doing poorly. They're not taking their meds. They're not coming to mental health. And they're about to lose their housing because mom can't deal with them anymore. We've seen this over and over. That person would qualify for care court because they're at risk of failing. And some clients are willing to do it. And so that's management.
Thanks, Brock. And there's another question. Melody mentioned because of where the public guardian office is situated in San Diego, it allows for sharing of information. In Tuolumne, is there any type of MOU set up with the guardian's office so you can share information, or how do you handle that?
Yeah, we have an MOU with the Public Guardian's Office. Information shared is still restricted by HIPAA and CFR 42 for drug alcohol treatment. And we are an integrated agency, so we have to go by the more restrictive standards. And so, but it's not really usually a problem. I mean, usually clients are willing to sign releases of information if a case manager persists, and you just have to be willing to keep trying. And very rarely are we unable to talk about a case, but we always, and I'm sure they do this in San Diego, are aware of privacy, and it's what a need-to-know basis.
Melody, anything else you would follow up to that on how you consider, how it's considered, what information is shared?
I think it's an ongoing issue. It's something that we try to navigate because this has never been done before. So we always try to go with an abundance of caution and make sure that we respect people's confidentiality, which is why, for example, if somebody was placed even on a temporary conservatorship, we still want to get a release of information just to respect that person's confidentiality.
Thank you, Melody. And Dari, I was wondering if you could come on to answer a question that we got. And the question was about the reconsideration to a higher level if care, as somebody steps from a conservatorship into care, how that's assessed, and if how teams pivot or assess the appropriate level that they're receiving. So Dari, did you want to speak to that?
Sure. Thanks, Patricia. I'm glad you raised this because I think this is a really important point. The CARE Act process is definitely not about letting people fail or wait or riding the process out until they fail. So there are a lot of different safeguards in place, both in the statute and I think also just in practices that exist outside of the statute, not to let that happen. So first, I want to speak to this point about collaboration that we've been stressing throughout the presentation. So if we do have a person who perhaps may have been eligible or almost eligible for conservatorship, and then a petition for care was filed instead as a less restrictive alternative, and that's not working out, ideally those system partners that file the petition for conservatorship for care, in the first place would still be communicating. So for example, if it was the conservator who filed the petition, said, the court referred the court's referring this person to care because they may be eligible for this less restrictive process. Hopefully the conservator is remaining involved. Certainly the Behavioral Health Agency now knows the conservator, and so there's some opportunity just to communicate back and forth. Also, the way the CARE Act is set up, the process, there are regular meetings in place to check in on the person's progress. Ideally, there's also a volunteer supporter who's there to help them. And so the goal, of course, is to help the person through their recovery journey and certainly not to let them fail in any way. And in the event that care doesn't work out, that the person is unable to complete a care agreement or a care plan, at this point, the Behavioral Health Agency is involved. They're providing services or they're trying to provide services, and they know this person. And so they're going to work, again, with system partners, whether it's public guardian, public conservator, APS, hospitals, whatever the partner may be, to help to, hopefully refer this person or figure out what services may work for them.
Thank you, Dari. Melody, Brock, would either of you have any follow-up to that question?
Yeah, the judge can order a reevaluation of conservatorship as well. But, it does make it difficult if they're in the community and not in a hospital. We, as Dari said, we are working usually pretty intensely with the client, even if they're doing poorly.
I agree.
So again, the learning objectives for this session were that by the end, you would have had an increased ability to identify those unique aspects of care, including the different paths in and out and the range of services that can be included. Understand how care can be a less restrictive alternative and how it can be considered at different parts in the conservatorship process. And then also describe the role of a public guardian and conservator in the care process. Of course, we have additional resources if you feel like you need more information. On our website, we have a training and resource library, which are searchable by different audience types and topics. If you want further information about the care process or eligibility or care plans and care agreements, we also list upcoming trainings that you can register for and attend, a county directory of available county BH and court websites that are specific to care, and then FAQs, which again are you can filter by topic. There are a number of ways to get a hold of us, and there's no wrong door. So that QR code will take you to our website. We have a listserv that you can join. We'll link to that link in these training materials. There's also a technical assistance request form that you can submit, a technical assistance request form that's specific for data, if you're in charge of collecting data. There's also a stakeholder feedback form. But there is no wrong door, so we have that email address. Just wanted to point out, again, if you are new to care, both on the training and resource page, we have key trainings and resources pinned to the top, which provide some introductory level information to care. So if you aren't sure where to start, those are a good place to start. And again, our email address, if you have questions or you're looking for a resource, please feel free to reach out. Thank you, and let us know if you have any questions.